thank you very much for giving me the opportunity to speak to you today about what I think is a very important issue, the growing threat to property rights. And I'm sorry this is going to cast a rather damper on the proceedings. We just had a very uplifting speech, and this one is anything but. Because I need to talk to you about how many threats there are in a whole number of different areas. And if we look at some of the recent acts and bills, many of them do affect the agricultural sector and therefore also agricultural land, but often it's land beyond farming land as well. Then there's the Expropriation Bill of 2015, which covers property of virtually every kind and is very important, so I'll spend a bit of time on that. Then we also have BEE, particularly the new generic codes, which came into force on the 1st of May this year, which now have major implications for ownership rights. And also significant, I'll deal with it very briefly, are bills which affect the private security industry and the mining and oil and gas industries. So let me start with land claims. And we had the reopening of the land claims process. In the middle of last year, the Restitution of Land Rights Amendment Act became operative, and under it we've already had at least 56,000 new claims lodged. That was a figure given in April, so it's probably higher by now. Also, the new window is open until June 2019, so there's basically 4 years still to run. And the government expects to receive 379,000 new land claims, which it estimates could cost $179 billion to settle, according to its own regulatory impact assessment. But the state can't afford $179 billion in compensation. We're hearing increasingly from the finance minister that tax revenue is not going up at the same rate at which expenditure is going up on public service wages and grants and various other things, ESCOM, parastatals with lots of funding needs. So there's a question as to how this is going to be afforded. Land claims, we hear from Agri-SA, have in the past sometimes been inflated and sometimes they've been lodged without adequate proof. In fact, Agri-SA has gone so far as to say that the Commission has pretty much given up on investigating land claims, and that very often all that matters is the existence of a completed form in a file, and that this has also given impetus to the reopening of the land claims process because it's become in practice a lot easier. According to Agri-SA again, the existing land claims process, that which ran until December 1998, when the first window closed, has been more damaging to commercial agriculture than the Anglo-Boer War. And a lot of the reason is because the uncertainty about title that is created and which goes on for a very long period. We have at least 8,000 claims from that initial round which have not yet been resolved. And some figures put the number of unresolved claims much higher, at about 13,000. Now add on the 56,000 plus new claims, and it's a huge administrative burden for the government. It's probably going to take at least another 20 years to get through all the new claims. And of course, the claims may not cover only farming land. I think there's a misconception there. But in fact, claims can extend to land of any kind, whether it's residential, commercial, industrial, mining, community-owned, state-owned land, all of it can be claimed. And that became very evident recently with a claim that was gazetted, lodged by a chief over much of Pretoria, and it covers properties falling within all of those categories. Suburban houses, also the whole of Mamlodi, and a whole number of industrial and commercial and so on developments. And it's this prolonged uncertainty which again is the key problem. Already, as illustrated with Pretoria North claim, what you've had is sellers wanting to sell, but buyers being very uncertain about buying because are they going to really acquire title? And banks being worried too about extending mortgage finance. It's another uncertainty which creeps in and encourages banks to say no. The Property Valuation Act has just come into force from the 1st of August this year. The new Valuer General is appointed by the Minister and specifically is made accountable to him, but he's also supposed to function independently and in an autonomous way. The The role of the valuer general is to value all property which is targeted for land reform. And according to the Act, that property expressly includes both land and accompanying movables, the movables which are contemplated to be acquired together with the land. So if it is a farm, then obviously tractors and the like would also be valued by the valuer general. According to the Act, valuations must be based on market value, straightforward enough, but also on current use of the property, and it's very hard to assign a monetary value to the current use of the property, and also to the history of the acquisition of the property. Again, how do you put a sort of monetary value on what its history has been? And in addition, valuations must also be governed by criteria and guidelines that will be gazetted by the land minister from time to time. So there's great uncertainty there too as to how that could affect the valuation process. Then we look at the Agri-Land Bill, as I call it for short because the whole name is a real mouthful, the Preservation and Development of Agricultural Land Framework Bill of 2014. Comment was invited on that, expired on the 31st of May this year. I think a lot of people were unaware of the bill, including myself, until I'm afraid rather the last moment, because I'd been focusing on the Expropriation Bill. But potentially this one is more damaging because it says that the Department of Agriculture, Forestry and Fisheries is to become the custodian of all agricultural land in the country. And the wording here is taken directly from another act with a long name, the Mineral and Petroleum Resources Development Act, which also vests mineral resources in the state for the benefit of all South Africans. Exactly the same wording is now used in the Agri-Land Bill. And that raises real questions as to what are the implications of this, particularly if you look at what the Constitutional Court said in the Agri-SA case about an unused mining right. And I just need to give a little bit of factual background here. This case arose when a company called Sebenza Pty Limited bought an unused coal mining right in 2001 for R1 million. At that time the MPRDA wasn't yet in force, but it did come in 2004. Because it was an unused old order right, they had a year to convert it to a new order right, but they couldn't afford the R1.5 million application fee because of grave financial difficulties, in fact leading to liquidation. And so the mining rights ceased to exist after a year, and Sebenza claimed it had been expropriated. Agri-SA took over their claim and brought it before the courts, and the Pretoria High Court agreed. They said Sebenza used to have all the competencies of ownership. Those competencies are now effectively vested in the state. It doesn't matter whether you call it custodianship or ownership, it's essentially still the same thing. And so they awarded compensation for expropriation, 750,000 rand. But when it went to the Constitutional Court, Chief Justice Mogoeng took a different approach. He said, for there to be an expropriation, you need, first of all, a declaration of ownership, and secondly, a matching acquisition of ownership. And if the state does not take ownership as custodianship, then that requirement is not met. So there is no expropriation and there is no compensation to be paid. So this idea of custodianship is a really disturbing one. Also important under this Agri Bill is that farmers are to have a right to farm, which will be subject to ministerial regulation. And there is obviously a good chance that that right to farm will in time morph into a requirement that you must have a lease from DAF. And perhaps your ability to retain that lease will depend on compliance with the Agri-BEE Charter, the way mining rights depend on compliance with the mining charter. If we end up with that, then we have effectively got what the EFF has long been recommending, that the state should be the custodian of all agricultural land, and that farmers should be able to use it under the terms of leases, which the state can determine. Also under this Agri-Land Bill, farmers will need state consent through an extraordinary, convoluted and complex process involving layers and layers of new bureaucracy if they want to rezone or subdivide their land. But the definition of rezoning in particular is such that, especially for high-value property land, it's not possible to get a rezoning for commercial, residential, industrial purposes only for another form of agricultural use, which will also result in the land being used for growing food for human consumption. You could argue that the wording is bad, but that seems to be the implication. Farmland which is not being used optimally may, I shouldn't have said will, may be expropriated at less than market value. But how will this work? Because you may, in fact, find that no compensation is payable. You might get the state and the courts taking the view that the farmers have effectively lost their ownership rights under this bill, that the state has custodianship, and there's really no need for expropriation because the state has control in any event, and since it doesn't have ownership, there isn't a question of expropriation or compensation. Other proposed land reform measures are still in the policy pipeline. Is the 50-50 proposal in terms of which commercial farmers might have to transfer 50% of their farms to long-serving farm workers, a proposal which both the African Farmers Association of South Africa and Agri-SA concur in saying will be unworkable. Who's in charge? Who manages in that situation? Land ceilings have been proposed. President Zuma began by saying they would be set at 12,000 hectares. They've already been revised down. 1,000 hectares for a small farm, 2.5 for a medium one, and a maximum of 5,000 for almost all farms, with the 12,000 being a very unusual and exceptional permission. And there are many farms which it won't affect, but there are, of course, also farms that are bigger than this and depend on economies of scale for their profitability. There are also to be limits on the ownership of farmland by foreigners. This is already in the Agri-Land Bill and will come into the Regulation of Land Holdings Bill as well. Many more rights for farm residents are envisaged. For example, under a 2010 draft bill, farm residents would get the right to do commercial farming on land belonging to a commercial farmer. And they would also have extensive rights to housing, electricity, water, burials, capacities, and so on. All of which I think are something that farmers increasingly fear. Rightly or wrongly, they are afraid of these things. And so there will be a tendency to try and evict residents rather than see them acquire all these rights. What we failed on is probably the most important of the land reform steps that we could take, that there's no more real talk of individual tenure for those who have customary land use rights in the former homelands. About 16.5 million people in that situation, and they will remain vulnerable to eviction by the chiefs, rather than acquiring a title which could serve as collateral for a bank loan. Often what we're talking about is creeping land nationalization, not really redress. So, for example, under the redistribution of land program, since 2006, the government has bought land and kept it in its own name. It then leases that land to place lessees. Initially, there was a possibility of getting an option to buy. That has been taken out to the great dismay of many farmers who say they need to be able to acquire ownership. They don't want to remain tenants of the state, vulnerable perhaps to eviction in any number of circumstances, and with whatever improvements they make effectively going to the benefit of the state. Then we come to the expropriation bill. And I'm going to give an example of how it could work in practice. So the city of Johannesburg might want to expropriate houses and commercial properties along, say, Louis Bourgeois Avenue, which has been identified as one of the corridors of freedom. The idea is that you use a transport node and then you create social housing or much denser housing along that transport node for the benefit of those who now live very far away. How would it work for those homeowners or business owners? And of course, Orange Grove is already very much a mixed race area. This is not something that's going to affect white people alone. There will be preliminary negotiations that the city of Johannesburg must enter into. If you don't like the price that's offered, you can object, and the city can simply refuse to respond to your objections. It doesn't have to give reasons in writing. It simply says, no, we don't accept what you're saying. Then it can serve notice of expropriation on all the homeowners, let's say, or business owners. Say that those notices are served on the 1st of November. Ownership will pass automatically to the city on the date of expropriation set out in the notice. which could in fact be the very next day. I've suggested here that it could be the 8th of November. The right to possess these houses or other properties will pass automatically to the city on the date specified in the notice, which could be the 15th of November. The only time limit which is given in the bill is that you can't have ownership passing the day before the notice of expropriation is served. In addition, the city can delay the payment of compensation to a later date than when it takes possession. So say it says it's going to pay on the 1st of March 2016, you're going to have to hope that it actually pays its bills on time, because there are many organs of state that don't do that. So compensation will be based on market value, less the 4 discount factors in the Constitution, things like the history of the acquisition of the property, difficult to quantify, the purpose of the expropriation, the current use of the property, something which could be more easily quantified, the extent to which the state has previously helped to buy it or helped in its capital improvement. So it's a bit of a thumbs up, but say it ends up as being 30% less than market value. It could end up being less than that, it could end up being more. Now, sorry for bad grammar here, if the owners don't sue for more within 60 days, then they are deemed to have accepted the amount of compensation offered. In that short 60-day period, you've got to find a lawyer, you've got to work out all the finances, you've actually got to sue, to issue summons against the City of Johannesburg, and if you don't, you're deemed to have accepted it. Right. If you do go to court, and at the end of the day you're not awarded more than the City of Johannesburg has offered you, then you have to pay not only your own legal costs, but also all the state's legal costs, and those become a first charge against the compensation payable to you. So they deduct their legal costs and you get the balance, which is another major deterrent against actually going to court. So if the dispute does go to court, the other interesting thing is that the court can look only at the amount of compensation. It cannot look at the validity of the expropriation, whether it really complies with the constitutional criteria. The capacity to do that was included in the 2013 bill. It's not included in the 2015 bill. That clearly indicates the intention is that the court should not be able to look at validity. Homeowners, in other words, will have fewer rights than drug lords, whose products can't be seized by the police without a court for order in the form of a search and seizure warrant, and who can't have their products confiscated by the state without also an asset forfeiture order issued by the courts. But when it comes to ordinary, lawful property owners, they don't have that protection. So we argue at the IRR that the expropriation bill is unconstitutional, that Section 25 of the Constitution lays down various criteria, that the expropriation must not be arbitrary or irrational, that it must objectively be in the public interest as defined in the Constitution, and the definition there is fairly limited to instances of land reform and more equitable access to natural resources. The bill has a definition which goes way beyond that, and it must objectively be accompanied by just and equitable compensation, which strikes an equitable balance between the public interest and the interests of those affected. So we say if there's a dispute which arises through this failed process of negotiations, then the state should have to go to court for a resolution of that dispute. It must seek a declaratory order that the expropriation complies with all constitutional requirements. And only if it's able to do that should it be able to proceed. Of course, this is what ought to be, because when you have guaranteed rights in a Bill of Rights, the onus lies on the state to show that they are fulfilled. And the only relevant time to do it is before the state acts in a way which breaches them, because a remedy after the effect is not enough. Section 34 guarantees access to court, absolutely infringed by this bill, which prevents the courts from looking at the validity of the expropriation and limits access on the amount of compensation. Section 33 guarantees administrative justice. It says that administrative action must be reasonable and procedurally fair. But here the City of Johannesburg can pretty much act as a judge and jury in its own cause in deciding what property it's going to expropriate and on what terms. Section 26, nobody can be evicted from their home without a court order authorizing this. Also forgotten in the Expropriation Bill. So we've developed an alternative bill in which, as I said, we would say if there's a dispute, the City of Johannesburg can't just proceed. It must go to court and get an order confirming that all these criteria have been met. In addition, we argue that compensation must be based not only on market value and the 4 discount factors, such as the history of the acquisition of the property, but also on compensation, damages for all direct loss resulting from the expropriation. That's in the current Expropriation Act, and there's no reason to exclude it. It would include things like moving costs, or if you're running a business from particular premises, your inability to generate an income until you have a replacement property, and that sort of loss needs to be compensated as well. And also that the City of Johannesburg should have to pay in full at least 15 working days before it is to take ownership of the property, and then if it fails to do so, then the notice of expropriation would automatically fall away. So there would be a real sanction for making late payment. Unfortunately, the Department of Public Works is unconvinced by all these arguments. It's assured me that their own bill is constitutional and the alternative bill that we've developed is not. So that's another argument that we're busy having now. There are also major risks to the mortgage market from the expropriation bill. Under the government's version, a mortgage ends when ownership passes to the state, the same as under the current Act, but there are nevertheless big differences. If the compensation is less than market value, then it may not be enough to cover the amount of the outstanding loan. At present, under the Expropriation Act, you get market value plus damages for direct losses plus a solatium. So it's unlikely that the compensation is going to be less than the outstanding loan. Now we're moving into a very different situation. There's also a real question about when a bank is going to be paid, because it will only be paid when it's reached an agreement with the owner on an apportionment of the compensation, or if it's got a court order on that issue, and it can of course take a very long time to get a court order. So again, there's a risk of mortgage debts not being fully repaid, another reason for banks to be wary of going into the mortgage finance market. To deal briefly with the risks of the new BEE generic codes, which came in on the 1st of May, the BEE ownership target is formally still 25% plus 1 vote, but under the preferential procurement rules, for example, there's an 80% target for larger enterprises, those with annual turnover of 50 million rand or more. In other words, they must aim to have 80% of their annual goods and services from BEE firms. In the past, it was enough to buy from BEE firms with 35% black ownership. Now, 52% of those purchases must be from BEE firms with 51% black ownership or 30% black woman ownership. Slightly different requirements for qualifying small enterprises, a 60% target, of which 15% must come from 51% black-owned firms. This is a priority element under the codes. If you don't attain a minimum score, your level of BEE contribution is reduced by 1 level. Enterprise and supplier development, it's still 3% of net profit after tax for larger enterprises or 2% for QSEs, but all of it must go to 51% black-owned firms or it doesn't count. And it's also a priority element, and if you don't meet a minimum, then you're penalized. In addition, we know as Eskom is what Eskom is up to. It's saying that it will only buy coal from suppliers with 51% BEE ownership, never mind the 26% goal in the mining charter. What I've also heard is that the Public Works Department in practice wants 51% BEE ownership before it will enter into long 10-year leases for government departments wanting to rent property. Many companies are thus under pressure to do BEE deals in order to raise their BEE ownership to 51%. But actually this, in terms of international principles of law, amounts to indirect expropriation, where the state might not acquire ownership, but the owner has lost so many of the competencies and the benefits of ownership that it nevertheless counts as an indirect expropriation, but our expropriation bill will not recognize it as such. Other threats, very briefly. There's a private security industry regulation amendment bill under which foreign companies working in the private security industry will have to transfer 51% of their ownership to South Africans also an indirect expropriation. There's the Mining Amendment Bill currently back before Parliament, in terms of which the Mining Minister may obtain the power to control both prices and exporting of strategic minerals, mainly designated ones as well that are needed for local beneficiation. Again, an indirect expropriation according to international principles. The oil provisions in that bill, which may be separated out and put into a different law, state entitled to a 20% free carried interest, and also to a further stake, which could be as high as 80%. It's entitled to that stake at a price it is willing to agree, which means that oil companies at least don't have a very strong negotiating position. There are also threats to patent rights and other forms of intellectual property, which I'd be happy to elaborate on if people are interested in. Why do we have all these threats? The effect, of course, is already to be choking off foreign direct investment. Inflows were more than outbalanced by outflows in the past year, and I think that pattern continues this year. We have terribly limited growth, as we saw from the slides before, 1.4% last year, very unlikely to be more than 1.5% this year. And on a per capita basis, the situation is even worse. We have an unemployment crisis. So why is the government not doing everything that it possibly can to boost investment, to get the growth rate up, to make sure that we have millions of jobs being created as the National Development Plan calls for? And it's because the policies that I'm talking about are all part of the National Democratic Revolution, which is far more important to the ANC and its allies than the National Development Plan. This is something to which the ANC and its allies have been committed since 1969. According to the SACP, it's the NDR that offers the most direct path to socialism and then to communism. The ANC never directly espouses that goal, but it does constantly reiterate its commitment to the National Democratic Revolution at 5-year intervals, most recently at Angol in 2012. And one of the goals of the National Democratic Revolution is to eliminate existing property rights. It's put in slightly different word, that the aim is to eliminate apartheid property relations. But the word apartheid is essentially a red herring. What has been put at risk is the property rights of all South Africans, black and white, people who now own their own homes, people who have customary land use rights. The whole variety of property can increasingly be taken by the government. The aim is also to achieve demographic representativity in every sphere on the basis that this is the norm, but that's actually not so. If we take the BEE rules again, for example, that there's a 60% target for black representation at senior management level. This is based on the fact that Africans make up 75% of the economically active population. So 60% seems reasonable, and some of the targets lower down are 75% or more. But then look at the definition of the economically active population. Everybody between the ages of 15 and 64 who works or wants to work. So we also have an African population of which more than 50% is under the age of 25. So the EAP as a whole is hardly a realistic measure to use. And if you start looking at economically active Africans within the right sort of age group, say for management, senior management, call it 35 to 64, then Africans within that age group make up 38% of the overall economically active population. So we are being pushed in a certain direction based on criteria which ignore a whole number of important variables. The NDR, as I said, offers this most direct path to socialism. And this is not just the words of a sort of splinter group, the South African Communist Party. It's never stood for election in its own right, but at least 40% of cabinet members are known past or present members of the SACP. The Communist Party automatically acquires 30% of parliamentary seats and probably more. It has deployed its members throughout government, and it has enormous influence on the ANC, not only now, but stretching back decades in time through the period of what is often called the struggle, including the last 10 years of it when it became a people's war. And part of of the reason that the ANC is keen on this is that if you increase dependency on the state, then it also means that people are less likely to vote against you. And you can see that in the statistics. The people who most regularly vote for the ANC are the people who, through our very bad schooling system, are generally unskilled and are very often unemployed. And it's the middle class which is much more likely to jump ship to the DA. So the ANC again has an electoral reason to want, for example, to encourage land claims in large measure by chiefs, for example, under which the people living on that land would find that they have no security of tenure, are very vulnerable to eviction by the chiefs, and will also, of course, be open to the influence brought to bear on them come election time. But we do have countervailing factors too. There are critical voices in the media, in opposition parties, in civil society. We still have a very strong private sector, which is one of the great strengths of South Africa. If we have 70% of jobs still in the private sector, this is really something which means the private sector should have influence. There's growing anger and disillusionment, I think, with ANC performance over issues such as Eskom and Nkandla, and the state is approaching a fiscal cliff, with revenues not expanding as fast as expenditure. Public debt is growing, the budget deficit is growing, and so all of this makes it more difficult to afford things which further constrain growth, limit investment, and the like. We also have what we sometimes call a verkrumpt, a split within the ANC. In other words, there are many people within the ANC who are increasingly worried about the direction in which the country is going, the direction of the economy, and where all of this is going to lead. And we have sound alternative policies being devised. This is something that civil society in particular can do. For example, we've developed a policy of economic empowerment for the disadvantaged instead of BEE, which would be race neutral, which would seek to promote growth, investment, jobs, all the right things that could really make a difference in enhancing opportunity. And we believe it's possible to wage and win a battle of ideas. But this is the battle that we need to win, because policies at the moment are based on predominant ideas which are very much endorsed often by the media about a statist approach which people believe will still work. And we need to show that experience around the world shows over and over again that the poorest countries are those in which the state controls and owns the most, and the most prosperous ones are those in which the free market is able to operate. Thank you.
Wow, that sinks in. Does anybody have any questions?
What can we do?
I was going to ask, what are the intervention points?
It's really important to get involved in every battle. The key battle now is the Expropriation Bill. That's before Parliament right now. And I'm often quite disillusioned at the extent to which business doesn't stand up and be counted and say this is an appalling bill. It puts the rights of everybody at risk. We have something like 8.6 million black homeowners now, and all of their rights are just as much at risk as those of the 1.1 million white homeowners. And we have an economy which is very much at risk from this bill. And yet, quite often we find a general sort of silence from business, or too willingness to accept that the bill will be used sparingly. I think it could easily lead to a complete free-for-all. National departments, provincial departments, municipalities, 700 organs of state that all have powers to expropriate in these vast, wide-ranging circumstances with so few controls. I think they'll be starting to expropriate from each other before long. Because the municipality will want to have what the national department has, and vice versa. So business needs to speak out. We see it now a little bit in the mining sector, but it needs to expand much more. Where we come up with an alternative policy, we battle quite often to get the word of those policies out. The media, again, will give endless attention to certain issues, and rightly so, like in Nkandla. But the threats in the expropriation bill don't seem ready to have registered with the media. The importance of having a constitutional alternative hasn't been given prominence. So also, again, if civil society can create links with business organizations which can help to spread the word, then again, that, I hope, begins to influence the way in which the whole society thinks about these important societal issues, where it's not possible for the ministers simply to get away with the kind of claims they make, because there are people to say, but hang on, we know more about this bill and we don't think it's going to work in the limited way that you're sketching. We think it's going to have major ramifications for all of us, and that would begin to make them rethink. So we all have to get involved in every way to change the climate of opinion. It's that battle of ideas.
Thank you. Anything further? Thank you, Dr. Jeffrey.